Are we supposed to hit continue?
That or leave.
See what happens. Oh, okay, you're all back. Now what? I've obviously taken Renee's place today.
Well, that's fine. I'll make you do all the work.
Oh, now you have.
Darn.
Well, Nora, how are things in TO?
Just the same.
Just the same? Sounds like Santa Paula. Nothing ever changes much.
We were in Santa Paula for a wedding, had a great time.
My wife had 6 of her high school classmates with us this past 5 days. And we sort of collapsed last night when they left.
How fun to still remain friends with people from so long ago.
Well, they kind of bunch of them. And as we got off the ship, they loaded it up, and that was the ship that ended up in quarantine for a month.
Wow.
So we thought we were awfully lucky we didn't stay on that ship for a month, rolling
Truly.
around out there.
Truly. Wow.
But they Zoom every Friday
Are we
now
testing?
and
Testing?
get
Testing?
together every once in a while, and so they're fun. They're a lot of fun.
That's so neat.
Excuse me, commissioners, can you hear me? This is Marilyn Miller.
Yes.
Yes.
Yeah.
Thank you. I'm using a headset.
Bye.
Good morning, commissioners.
Good
Morning.
morning.
Good morning.
Morning.
Good morning, commissioners. Can you hear me okay? Hello?
Renee, if you're there, let me know when we're ready to start.
No, he's there. Renee, can you hear us? There he is. Good morning, Renee.
Good morning. Can you hear me okay?
You're on mute. If you can hear us, Renee. So we try to launch the plane here. Renee, are you there? What's happening? I don't know. I know he's there, but I'm upstairs. Well, let me see what's going on. Let's see here.
Good morning, Commissioners. Can you hear me okay? I don't think they can hear me. Commissioners, can you hear me okay?
We are sending Luz down. Just hold on a minute.
Good morning. Can you hear me okay? Commissioners, 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 can you hear me okay? Commissioners.
Echo.
Everybody, there's a technical issue on Renee's end. So we have the crew in the hearing room right now trying to figure that out. So bear with us. Every time it seems like it's a challenging adventure, but we pull it off, but it takes a moment or two for sure. So apologize for this.
Commissioners, can you hear me okay? Commissioners, can you hear me okay?
Who in IT do I need to call?
It's probably Eddie, but I.
Renee, can you hear us? I see your mute is off. No.
Can you hear me okay?
Bless you.
Thank you.
It should be on, and they should be able to hear you.
Commissioners, can you hear me okay?
Your Zoom sign should be ClickShare and SDI, right?
And that's what he has, ClickShare and SDI.
Okay.
So let's go ahead and,
Are we not hearing it? Is that the problem? Or?
Those commissioners cannot,
They can't hear it.
Moving, it's just that they can't hear me for some reason.
yeah, because this is not the SDI part to it.
It's already set up.
Commissioners, can you hear me okay?
Hey, what's this right here?
It's muted, so it goes through the ClickShare instead of through the speakers here.
we do have.
Now can we try it?
Go ahead, give it a try.
Commissioners, can you hear me okay?
Yes.
Yeah, they can hear me now.
Yeah,
Well, it's because they told me I need to be muted from the booth, so.
so we're good now.
Okay, I think we're good now. We're good now.
We're good now?
Yeah.
Okay, so, yeah, so I think we're good now. All right.
Thanks, Eddie.
So what happened?
So the mic was muted off
Oh,
because it said that they're gonna control it by the booth, so
okay.
the video and the mic were muted, but I guess the
So it's just supposed to be.
It looks like our audio issue has been resolved. I apologize for the delay.
Thanks,
Okay, are
Renee.
we ready to begin?
it's on my end, but it's muted.
You ready, Renee? We can go
Yes,
ahead and
we're
commence?
recording.
Okay. Okay, great.
Okay. Call the meeting of the Ventura County Planning Commission for November 18th, 2021 to order. Mr. Verduzco, will you please call the roll?
Commissioner Boydston,
Here.
Commissioner Idukas,
Here.
Commissioner McPhail,
Here.
Chair King,
Here.
Commissioner Garcia.
Here.
Okay. Moving on to item 3, please stand with me for the pledge to the flag. Ready, begin. I pledge allegiance to the flag of the United States of America and to the republic for which which
which
it
it
stands,
stands,
one nation, under
under
God,
God,
indivisible,
indivisible,
with
with
liberty and justice for all. Please be seated. Okay. Okay, item 4, consent calendar has one item. Resolution authorizing continued remote teleconference meetings of the Planning Commission. That's resolution 21-13. Is there any motion on the resolution?
Move approval?
Second,
Okay, it's been moved by Commissioner Dukas, second by Commissioner McPhail. Any further discussion? All those in favor indicate by saying, oh, nope, let's go back. Let's call the roll. Mr. Verduzco, call the roll, please.
Commissioner Boydston,
Aye.
Commissioner Idukas,
Aye.
Commissioner McPhail,
aye.
Chair King,
Aye.
Commissioner Garcia.
Aye.
Okay, resolution passes. Item 5 is time set aside for comments by citizens on matters not appearing on the agenda with a time limit of 5 minutes. Secretary Verduzco, do we have any requests for comment?
For public comments, item 5, we don't have any speakers at this time.
Okay, well, just because I overlooked it, why don't we put up the instructions for how to make a comment by email in case somebody wants to make a comment on item 5 and didn't get it in on time.
Welcome to the November 18th, 2021 Planning Commission hearing. If you wish to make a comment on a specific case item, please email your comments 250 words or less to planning.pccomments@ventura.org. Please indicate in the subject line the agenda item number. Item 5 is public comments not addressed on this agenda. Item 7 is Hollywood Beach violations. Staff will read your comment to the Planning Commission. Comments received after an agenda item will be made part of the record if received prior to the end of the meeting. Members who wish to speak, please press the raise hand button on Zoom now, or if participating by telephone, please press star and then 9 to be queued for this agenda item 5.
Okay. If we get any comments under agenda item 5, Secretary Verduzco, just bring it to my attention and we will hear the matter as long as the meeting's still in progress.
We have a
Moving
member
on
of
to
the public
agenda
with,
item 6, approval of the minutes of October 21st,
Chair King?
2021. Yes,
we have someone with the raise hand function, I believe for agenda item 5.
okay, then let's back up. Let's see, go ahead. I don't know how we're going to proceed, but let's move ahead with accepting the comment. Yeah.
The individual could state your name before you
Hello?
commence.
Can you hear me? Andrea Wishnow?
Thank you.
Yes, Andrea, you have the floor.
Okay. I just wanted to say that I feel that we are unfairly and unjustly singled out to remove a portion of our deck. We bought the house and in
Okay,
3
Andrea, I'm going to stop you right here. This agenda item is for issues not on the agenda. What you're trying to address comes later in the agenda on item 7. So we
Okay.
will recognize you for comments when that agenda item comes up, if that's all right.
Okay. Thank you. Sure.
You're welcome. Okay, anything else under item 5?
Not at this
Then,
time.
moving on to approval of minutes. And why don't we lose the screen on public comments so I can see everybody? Great, thank you. Okay, minutes of October 21st. Is there any motion or request to amend it?
Move to approve.
Okay, is there a second? Okay, it's been moved by Commissioner Boyston, seconded by Commissioner McPhail to approve the minutes as presented. Any further discussion? Then Secretary Verduzco, will you call the roll, please?
Commissioner Boydston,
Aye.
Commissioner Idukas,
Abstain.
Commissioner McPhail,
Aye.
Chair King,
Aye.
Commissioner Garcia,
Aye.
Okay, minutes stand approved. Moving on to item 7. And this is 9 separate appeals of notices of violation. Let me start with the disclosures. At this time, I'd like to ask each planning commissioner to state on the record whether or not he or she has received any oral or written ex parte communication regarding this agenda item. Please disclose the substance of that information only if that information is not contained in the record before us at this time. Secretary Verduzco, will you poll the commissioners?
And Chair King, just one more thing before Renee polls the commissioners. If there's any ex parte communication that was specific to one of the individual addresses, you should make that clarification. Or if it's general, that's fine. But if it is specific to one particular address, you should state that as well, just to be clear. Thank you.
Thank you, Director Ward. Mr. Verduzco?
I'm sorry, is it a roll call or are we allowing speakers?
You're just polling the commissioners on disclosure.
Got it. Commissioner Idukas,
I have no disclosures.
Commissioner Boydston,
No disclosures.
Commissioner Garcia,
No disclosures.
Commissioner McPhail,
No disclosures.
Chair King,
No disclosures. Okay, and the way this is going to work for our one member of the public that wanted to comment earlier is we will first receive the staff report. Staff will then, or commissioners can then ask questions of the staff, after which we will open it to the appellants for their comments. And ultimately, we will open it to the general public for comments. So everybody is clear on that. So at this time, I'd like to ask, and I believe it is Planner Miller. Are you the one that's presenting on this?
I am Chair King. Thank you. My name is Marilyn Miller. Good morning, Chair King, members of the commission. I am the Director of Planning and Redevelopment for the Harbor Department. I'm down at Channel Islands Harbor normally. I'm on loan, if you will, to the Planning Department to assist them in processing some of these cases that they have on their very large agenda. And I've been assisting planning and code enforcement. I'm going to share my screen, and I've not done this before, so if you will bear with me. Can you see that?
Yes.
Okay, I'm going to go to the slideshow from the beginning. There. All right, this is a consolidated hearing regarding 9 notices of violation for unpermitted and illegal decks constructed down on Hollywood Beach. I will tell you that one of the appellants, Mr. Sadow, who is PL 170048, at 3829 Ocean Drive has withdrawn his appeal. And the exhibit is number 5 on your packet, which the resolution with all the attached documents. He has withdrawn his appeal and he's indicated that he's going to remove his deck. So I won't be discussing his today. We'll be looking at 8 different of these encroachment issues. This is information on how a member of the public can contact the Planning Commission. This is a repeat of what Renee went over with you. And again, this is the 9 single-family residences located at the addresses listed on the screen, and I'll go over each one of those with you. This is a general location. Most of you, I'm sure, know where Hollywood Beach is. It's the area between the city of Oxnard and Channel Islands Harbor. It is unincorporated and part of the county, covered under the county's LCP. The coastal area plan land use designation on all of the sites is recreation. These are just maps showing the zoning, and the zoning is open space. Just some background and history of this project. The property in question is a narrow strip of land behind these residences that was deeded to the county back in 1932. And there was a deed restriction on that quitclaim deed that states that no building or structure of any kind shall be constructed. The property can't be used for commercial purposes. It was intended as public property, open beach recreation area. In July of 2016, Code Compliance received complaints on 46 of these potentially illegal decks. As is the usual process that code enforcement carries out, courtesy notices were issued. Some of the owners voluntarily removed the decks. Of those who didn't, notices of violation were sent out to 28 of the property owners. 13 appeals were received originally. 9 were scheduled for today's hearing. 4 have changed owners and new violations will be issued. And then, as I explained, the one property owner withdrew his appeal. I want to speak a little bit to the time issue on these decks. One of the reasons that was given by most of the appellants is that these decks have been in existence for quite some time, and that is true. They have been there for many years. I want to point out, however, that when they were built, they were not legal, they were unpermitted. And the fact that we did not issue notices of violation when they were built did not render them legal today. I'm going to go over each one of these properties. The first one is 3757 Ocean Drive. The owner is Unan. The appellant is their representative, Miss Christina Brewer. This gives you the dates that the notices were sent and the appeal filed. The reasons for the appeal here were arbitrary and conspicuous implementation of county regulations. I believe that they meant to say capricious. That the county allowed the decks to remain for decades, that no one's enjoyment of the beach or his property is compromised, and the owner did not install the deck. Why is it their responsibility to remove it? This is an aerial of the site. This is a front street view and a rear view of the residence with the deck. This is a close-up of the deck. It's approximately 19 by 13 feet, composite over wood frame. It doesn't appear to be attached to the residence. It may be attached to this concrete pad. There are some stairs. There are no utilities attached to this deck. The next one is 3903 Ocean Drive. The owner again is Union, represented by Ms. Brewer. And the reasons for appeal on this deck are essentially the same previously. They also add here that the deck protects the house from the sand that piles up every winter. The staff report went through each of the reasons for the appeals that were filed and responded to those. I will just reiterate that this is public property. It is a public beach, recreational beach, and that the decks, the fact that they have been there does not render them legal, and they were not permitted and are not allowed in the coastal area. 3903, here's the aerial, the front of the home and the rear of the home with the deck. These are close-up photographs. So this shows that this deck doesn't appear to be connected to the property at all. It's about 23 feet by 12 by 11 feet, and it too is composite over wood. It looks to be freestanding and there's no utilities connected. 3945 Ocean Drive, Bonnie Sleep Hack is the owner. The reasons for the appeal: the owner was not told of any violations when they purchased the home. They were told the deck was grandfathered in. Several of the appellants have mentioned that this is selective and unfair enforcement. And I will let you know that although you are only considering 8 of these today, there are a number of these out there, and our intention is that we will eventually issue notices of violation if necessary for all of these unpermitted and illegal decks. Here's the aerial of 3945, the front and rear. The deck, there are some stairs attached to this deck as well. All of these are generally around 20 feet by 10 to 12 feet. This is composite over wood. The stairs also appear to encroach onto public property and would need to be removed. 3949 Ocean Drive. The owner is Mr. and Mrs. Houston. The reason for appeals are similar to the other owners: arbitrary and capricious implementation of county regulations. The county has allowed the decks to remain. No one's enjoyment of the beach has been compromised. This is a wide beach. Nevertheless, it is public property, and we've explained the reasons for the notice of violation in the staff report and responded to each of these reasons for the appeals. Here's the front and the rear of this 3949 Ocean Drive. And then the size of that deck is similar to the others: 18 by 11, 18 to 12 inches high. There are no utilities connected to any of these decks at this point. 3953, Mr. and Mrs. Cameron are the appellants. The deck was also present when they purchased the property, and they state that there's nothing on the deck that prevents anyone on the public beach from using the deck. However, I think it's apparent by the photographs that these decks were meant to be used solely by the property owners, and that no one from the public is going to take advantage of a deck built onto the back of someone's residence. Here's a close-up of this deck, similar size and construction, and no utilities. 4001 Ocean Drive is owned by Mr. and Mrs. Green. They have filed an appeal based on similar reasons. This is the residence. The existing deck, 22 feet by about 10 feet. And it too is freestanding with no utility connections. 4017 Ocean Drive is owned by Nancy Fairchild. They appealed in March of 2017. They stated that it appears the deck has been there since the 90s. We don't dispute that assertion. Nevertheless, it was unpermitted at the time it was constructed, and it is not legal today. Here's the aerial of 4017 Ocean Drive. This is the front and the rear of the site. This deck also has landscaping material that is an encroachment as well. Further photographs, and then similar in size. 4033 Ocean Drive is owned by Mr. and Mrs. Carzell. Their reasons for appeal are similar to the other appellants. This is an aerial of their residence. Photographs of the home with the deck. The deck is essentially resting on the sand, and no utilities are connected. All right, that is a review of the particular residents that are at issue here. I want to go over the reason for the violations. This is a public beach area. It's designated coastal open space, and it is owned by the County of Ventura. The purpose of the open space zone is to preserve, maintain, and enhance natural resources, particularly recreational resources in coastal areas of the county. Decks for private use would not be allowed on public property zoned for open space. The decks are structures as defined under the coastal zoning ordinance, and a coastal plan development would be required for construction of a deck like any of these shown here. And only the property owner's lessee or authorized representative could obtain that coastal development permit. In this case, that would be the county. The decks at issue here are unpermitted, they are illegal, and they in fact cannot be permitted at all to the extent that they are located on public property. So the requests that we've received from the appellants that they be issued a license or a use permit or some sort of an exception in order to retain the deck cannot be accommodated. There is no pathway to permit these decks. Our recommended findings and actions. We recommend that you conduct a public hearing on each of the 9 appeals, that you certify that you have reviewed and considered the staff report and all the exhibits, including the appellant's appeal materials, any of the information that was submitted to you after the release of the staff report and submitted by the applicants, and all other public testimony. Find that these appeals are exempt from the California Environmental Quality Act. Find that they were constructed in violation of the Ventura County Coastal Zoning Ordinance, and I've listed the sections there for the reasons that were stated in those notices, based on the fact that they were built without permits. They're constructed on public beaches behind residences in unincorporated Ventura County, that they are development, and that no coastal development permit has ever been approved, nor, as I said, could one be. The decks were constructed either by the current owner or on behalf of the previous owners, and they are accessory structures to those uses. The current property owners are responsible for the violations set forth in the notice of violation. Construction of the decks are inconsistent with the county LCP, as they are intended for use by the adjacent residential property owners, and they were constructed on property designated as recreational public beach. We recommend that you deny each of the 8 appeals now before you. and that you specify the clerk as the custodian of record. I have included slides here for you for each of the recommended actions for each of the appeals, and we can go back to this if you need to when you are ready to take when you are ready to take action on these items. I've listed each one for you on a slide for clarification. That does conclude my presentation. I am available to answer any question, as is Doug Leeper, the Code Enforcement Director, sorry. And that concludes my presentation. Thank you very much.
Thank you, Planner Miller. Are there any questions from the Commission of Staff? Commissioner Dukas?
Yes, good morning. Thank you for that presentation. As I was reading through the appeals, one argument that I'd like to follow up with was someone who said that he didn't know anything about the deck. It has nothing to do with him. It was there before. It's not his property. Why is it his responsibility? I know that you just said that these decks were constructed on behalf of previous property owners. His point is, that's not my property. I'm not responsible. How does staff respond?
Well, our response would be that the deck is adjacent to or abuts the residential property. It was clearly constructed by a previous owner for the benefit of that residence, and that when you purchase a property, you take responsibility for whatever was constructed as a part of that residence. I would, I don't know if legal counsel is on, or if Mr. Ward would like to add anything further.
Well, let me just ask a corollary question. If someone bought the property and the multi-listings showed the deck as part of what you were purchasing, does that go to the fact that it is their responsibility, even though it is not on their land and they had nothing to do with its construction?
I would,
let me
try to assist.
I would say that if it is included in your real estate documents that it's a part of your property, I think that's evidence that it's obviously benefiting that property and is your responsibility. I would maybe ask Mr. Leeper and Mr. Ward to add to weigh in here.
Okay, thank you.
Thanks.
Commissioners, good morning. Doug Leeper, Code Compliance Director. In my 25 plus years in code enforcement, various jurisdictions, yes, we have used, in fact, used multi-listing information and real estate contracts to show that folks were either aware of that a condition, or it was included in some type of disclosure or offer these are a little different in that we've in code enforcement, we have had property line disputes with illegal construction in the past. This being coastal and county property with a deed restricted property, that just kind of adds more layers to that. And in this instance, we conferred with counsel to be certain that that we were on solid ground, as it were, moving forward, holding property owners responsible for conditions that were on adjacent property. And we were assured that that was the case, as it is an extension of the permit, the coastal permit, to have the structure there in the first place. And so, yes, all of that would be used in our case, and was in each of these moving forward, showing that the property owner benefits or has benefited or was aware of, or it was in a multi-listing in that, and that then contributed to the responsibility for the deck.
Thank you for clearing that for everyone.
My pleasure.
Okay. Other questions? Let's see. I think Commissioner Boydston's hand went up a fraction of a second before Commissioner McPhail, so we'll take you in that order.
Okay, it's my understanding that code enforcement doesn't just drive around and pick on people, that in fact, there needs to be a complaint typically filed before code enforcement comes out. I'm interested in what was filed as the complaint document, number one. And then the second part is a follow-up question. Has there been occurrences where structures have been built on the beach that in fact have been flagged as a code enforcement issue, and have they been removed? I know in other, there's some famous cases of surf places where structures have been erected and then have been flagged and have been removed. So in that instance, have they been removed at county expense, or how has that been done?
So I'll answer the questions. Yes, we are complaint reactive for various reasons, not the least of which is that was the board's direction, that code not be driving around finding things to notice. In this particular case, I was not here. I've been here about 4.5-5 years. This happened right before I got here. And my understanding is that we had someone constructing a deck on the beach adjacent to their property. We went out and stop worked them, as we do. We received a complaint of that. That individual, like some of the appellants here today, said, well, if me, what about everybody else? And provided us a list of 46 decks on the beach that they wanted us to do something with. And so we sent out courtesy notices, allowing folks an opportunity to correct that violation before any official enforcement began. Some did, many didn't. Then we sent out notices of violation, informing them that you do have to do this. If you don't, then there are various other enforcement remedies that may take place, to include possible abatement or removal of the deck at their expense. As you can see, some appealed, and I've had numerous conversations with both the appellants and other folks who are still maintaining their decks, awaiting to the decision of the commission today. As to removal of any other structures prior to my tenure here, I am unaware of any structures that have been removed by the county at county expense in the coastal zone. If the question is, could the county remove these at violating structures, the decks? My experience has been, yes, we can, if that is in fact what the powers that be decide to do. We would much prefer that the responsible parties, those being the property owners, take responsibility for this and remove them themselves. Can we take other actions on these properties? Yes, there are other actions such as fines and things like that can happen to motivate compliance. Again, my mantra in code enforcement is compliance is the goal, and we would like to see voluntary compliance. And so hopefully at the conclusion of this hearing today, that may encourage others to voluntarily comply depending on your decision.
Thank you.
You're very welcome.
Okay, is that all, Mr. Boydston?
Yes, that is. Thank you.
Okay, Commissioner McPhail.
Yeah, I have 3 or 4 questions. The first question is, why did it take 4 years to come to us?
Well, as I stated earlier, when I got here and discovered that we were in this position where we were holding property owners responsible for conditions on adjacent properties, I was completely, it was something new to me, even though I've been in code enforcement for 25 years. And so I raised some concerns, and there were numerous meetings to discuss that and provide the legal foundation and framework as to why this is appropriate and able to go forward. We started to move forward, and we hit the Thomas fire. And then that resolved, and we started to move forward again. There was a change in administration, and so we wanted to review it again to make sure that we were doing this properly. And that decision was reached, and then COVID hit. And so it's not been for lack of desire or need to move forward, but there have been some circumstances that have placed roadblocks.
So I'm just going to make a statement on the last of them. Even with COVID, we have been meeting almost monthly, and a lot of things have come up much newer than these, and they've come before us. So I'll just make that comment.
Yes, it wasn't an issue of the commission meeting. It was an issue of staff's availability. We were taxed with COVID compliance, and staff was looking at businesses that weren't adhering to the various public health orders, which at the time we felt was more of an urgency than being able to move these forward. That we could be wrong, but that's what was our response at the time.
Well, my comment was that we still had items coming before us that were initiated much later than 2017. That's all. Okay. I'm not sure why it was included in the packet, but the Coastal Commission report about the city of Newport Beach. And I understand, if I read it correctly, the reason they got in trouble was they asked for an amendment to their local coastal plan. And so the Coastal Commission put the brakes on that. But the city of Newport Beach, if I read it correctly, has volunteered at their cost to mitigate all the violations. And I guess my question is, if you're going to end up with 49 total violations, or since there's still more to come, it just seems to me that it would be appropriate for the county expense to remove those decks and not the homeowners, but that's just a comment. The thing that really did bother me is some of the comments by the homeowners was the decks help stop the sand. I find that hard to believe because they're flat and they're not going to stop anything. But with that said, since they're on county property, wouldn't the county be responsible to remove the sand that blows up against those houses every winter come springtime?
First of all, one of the things that I will add that I didn't in the PowerPoint is that I have been in discussion with Coastal Commission enforcement staff regarding these, and they have indicated that they are in support of what we are doing here today, that they could certainly initiate an enforcement action against the county if these decks are not removed. And I believe the decision, and maybe Mr. Edsel might want to clarify this, but I believe the decision in Newport Beach sort of supports that. The Coastal Commission would encourage removal of these. As to the sand removal, I work for the Harbor Department and we maintain Hollywood Beach and Silver Strand Beach. The homeowners regularly contract with a backhoe or whatever equipment is used to remove sand from directly behind their homes. We work with them in order to place that sand in an appropriate location. The county's LCP update that I believe you have looked at not in the not too distant past included a provision that coastal development permits will be required for that sand removal in the future. So it has historically been the homeowner's responsibility to remove sand from behind the homes if they so desire, and with a coastal development permit.
Well, see, that's where I'm going to disagree. It's county property up to those little retaining walls that some of them have. It should not be the homeowner's responsibility to get a coastal permit to remove that sand. Sand belongs to the county of Ventura, not the homeowner. So now you're asking the homeowner not only to remove the deck, but now they've got to go through the process to get a permit to remove the sand that's up against their house. So that sand belongs to the county. It does not belong to that homeowner. And the county should be responsible for removing the sand. And that's just my opinion.
I would have to ask Mr. Edsel if he has anything to add.
Oh, thank you. Just briefly, members of the board, my name is David Edsel with the County Counsel's Office. I wanted to just touch briefly on an earlier point about the city of Newport Beach. I'll add that there was some culpability there in the city found by the Coastal Commission that the city had sort of encouraged or not taken enforcement action against the homeowners. So part of that enforcement action by the Coastal Commission that required some payment by the city was due to finding some culpability, which I don't think is the case here as we're trying to enforce these as the complaints have come in. As for the sand issue, I haven't specifically looked into that, but I will just say, add to the point others have made about these encroachments, or excuse me, these illegal developments. They're so clearly ancillary to the property. I believe Commissioner Boydston earlier referred to surfing spots where there's, maybe a illegal structure, and that might be a case where the government entity steps in to take it down. But in situations like this, and as the case in Newport Beach, and there's been other situations up the coast, if it's so clearly ancillary to a private property, it violates the initial permit to allow the residents, and it's just frankly a code violation to extend their backyard onto other government properties. So we believe, that in this instance that the law and the precedent is on the homeowners to remove this.
I understand the deck. I have no problem with removing the deck. My concern is when they remove those decks, and obviously a large number have already done it voluntarily, which is a good thing, saves a lot of staff time and our time. But my concern is the sand. I cannot understand why a homeowner has to get a coastal permit to remove sand that does not belong to them. That's my point.
Well, I would add that, if you build a house on the beach, especially a beach that's windy, the sand is going to blow around. It blows higher than 18 inches off the ground. We get calls out of the harbor very frequently from people who have sand in their driveway and they want us to remove it. Our position has always been that if sand blows onto your property, then it's your responsibility to remove it.
Then they should not be required to get a coastal permit to remove it because it's not their sand. It may be on their property, but the sand does not belong to them. The sand belongs to you as the county, not them. And you can smile if you want, that's fine. But the sand does not belong to the homeowners. Their driveway, they can sweep it off, but I'm talking about the back or the front of the houses, however you want to call it, that are up against the beach.
If
Now,
I may,
probably they shouldn't have built their house right up against, the county property line.
I'll pick you up, Commissioner Pointston, in a minute. Let Commissioner McPhail finish.
But anyway, my last comment or question is, if I understand your presentation correctly, you still have a number of violations to send out. Is that correct?
That's correct.
If I may, we have pending cases from the original list reported of 46. In that time, we've also received some other complaints of offending decks. We do not have a comprehensive list of every property along Hollywood Beach or the county coastal, the coastal zone that the county is responsible for any other offending structures or decks. As we're not proactive, we have not gone out and looked for those. In each instance where someone has called, especially these appellants, saying, well, what about the other decks? They've been offered the opportunity, as was the original offending property owner who presented us with a list of 46, to report decks that they found were in violation. Since this time, we have discussed with administration if this is the proper time for us to go in some type of proactive position along the coastal zone that the county is responsible for, and provide a soft notice, if you will, that once this hearing is concluded and the decision has been reached, that this is what happened. This is the decision that has been reached. If you have an offending structure or deck, please remove it. And then if you don't, we'll have to take appropriate action from there. And so there are, I'll say numerous. I don't know, because again, we haven't done a proactive inventory to identify those.
Just out of curiosity, fires and pandemic aside, from the time you send out a courtesy notice and then a violation if you have to, how long does it take if they appeal it to get to us normally?
In my 5 years here, we've had 2 appeals go before the Planning Commission, and both of them have taken well over 12 months, because we're trying to resolve as much of it as possible before it goes to you. In both instances, as you can see, many of those that were appealing have fallen off, either come into compliance or withdrawn. As was the last appeal we brought before you. There were probably 23 issues at hand when they first appealed, and when it finally came before you, there were 2. And so we're trying to bring them as much into compliance before we get them to you as possible. And it's, the last one worked quite well, and they're coming into compliance now with your decision, and hopefully this will provide the same motivation.
Okay, thank you.
You're very welcome.
Commissioner Boydston, you waved frantically.
Well, I just think the conversation is veering off a bit when we talk about the sand issue. I don't think the sand issue is before us today. It's about illegal decks. There are, seems to me, the sand issue is being handled already by the county and the Harbor District. So I would just recommend we stay focused on the deck issue. What strikes me here is that I don't think there's anybody here that says the decks are probably not illegal. It's about responsibility to remove, which seems to me to be the question. And so I want to pose the question to code enforcement. You said that there was a number of back and forth and investigative tools that you used to decide responsibility. And I'm wondering which, you mentioned, real estate sort of transactions and things like that may have included language that the deck was there and part of the amenity of the house. Do you have definitive evidence of which of these 9 properties actually had a real estate description that the deck was there, as opposed to somebody that the deck wasn't even disclosed as part of the transaction? It's a little, seems to me a little flimsy to have evidence by proximity in some of these cases. Not all of them, but in some of them.
My apologies. We did not include that here, and I don't have it before me. I know that of the 46 that were originally reported, we did research on those that didn't voluntarily comply, and did find some previous real estate listings that noted that, and that's an oversight on my part that we didn't identify that on these 8 remaining today.
So is there the possibility of these 8 remaining today that some may not be absolutely tied to the homeowner as strongly as other ones are?
I guess that's a question for legal, for the county council. I would say, based on the proximity, and with the exception of one of the appellants saying, just saying it's not mine, it was there, and it's not on my property. The other 7 have admitted that it's there for a reason, for their use, to use as a sand barrier for the sand rolling, blowing up on their property. And so I would say those 7 are definitely admitting that they benefit from the deck and they knew it was there. So the 7th would be something for council to comment on.
Thank you. Yeah, I'll just add that to, whether or not there was adequate disclosure of the deck during the transaction, that's more of an issue between buyer and seller and issues of due diligence. It's not really an issue from the county's enforcement context. When you take over a property, you take over any violations on that property, and that's well established in the case law. So to the extent that they might argue that it wasn't disclosed or that they were told it was permitted, that's not really an issue between the county and the homeowner. It'd be an issue between the homeowner and the seller.
Well, I guess I'm trying to determine whose responsibility should it be to remove it. So if this deck was 10 feet away out in the beach and they still used it, is that different than 5 inches away, as far as responsibility to remove, county versus homeowner?
It could be, as I mentioned earlier, in an example of, the surfing point, surfing spot where there's a structure or a hut set up on the beach, that might be a different situation. You use the example of 10 feet or something. I don't know, that's a closer question. It's sort of a spectrum, but I think in all of these before you today and the ones we've looked at, it's just not a close question. These are right off the back. So yes, the further away you get, maybe there's more of a case that it's not the homeowner's responsibility. Again, it depends on the facts of each situation, but I just think in the context of these, they're basically extensions of backyards, extensions of back decks. It's not really a close call on any of these. There's, to the extent any of them are not attached, they're not attached by 5 inches or so. It's just, again, in the situation at hand, it's not really a close question.
And I would add, if I may, that depending, the decision before you is, are they legal? Can they remain or not? And when it comes to that decision, if the decision is reached that they are not legal, and I will note that none of the property owners have said we own the property the deck is on. You've mismeasured our property line. It's ours, and we do in fact have permits and approvals to have it there, which would be a legitimate argument to allow them to remain. So based on your decision, then we'll look at each case individually. If the property owner decides to remove them themselves, that's fantastic for us, and that's what we hope the decision is. If they decide not to, then I'll confer with county council and administration as to how they want to proceed with each one of those that do remain. And it could be additional enforcement through fines or penalties. It may be civil action. It may be abatement where we go in. We have several different avenues that we could pursue, but that's not something that I would be able to reach a decision on any one or all of them today until a decision is reached, and then the property owners are given an opportunity to correct the violation themselves.
So it's not our decision today to determine how they will be removed.
That's correct. Yes, thank you. Your decision is, are they legal or are they illegal? And so then we'll move forward from that. And again, as you know, if the decision is reached that they are not legal and allowed, the property owners have additional due process that they can afford themselves moving up through various other appeals. And so, thank you, sir.
Thank you.
Okay. Anybody else on the commission?
Hi, I had a comment, just out of 2 comments, 1 question and a comment out of curiosity. County Council mentioned precedent for the property owner abating the violation. I was just curious if that precedent that was mentioned is really similar to the circumstances that we're talking about here. And my comment is that I would agree and support that that for code enforcement to take a more proactive approach as opposed to reactive.
Okay.
Thank you, Commissioner. As far as the precedent, I guess what we're looking to is that Newport Beach one is an important precedent because actions taken here can be appealed to the Coastal Commission. Coastal Commission's the statewide body that ultimately oversees coastal development in the state. So in that situation, and correct me if I'm not answering a question, but it was a similar situation. the extensions of the backyards were deemed illegal. They were not allowed to remain, even though the city had attempted to find ways to allow them to remain. And ultimately, it was on the homeowners to remove them. So when we talk precedent, I think I'm not saying that's the only precedent, but I think it's an important precedent because it was an action by the Coastal Commission, which ultimately oversees these things, coastal development actions. And as Ms. Miller said, she's been in contact with them, and that's I think how they would come down in this situation as well.
I think it may be important to note too that at no time has county staff tried to find a method or a way. We've listened to the appellants and the property owners as to what they would like to do, some type of a conditional use permit or encroachment permit or something that would allow them to remain, even with monetary compensation, et cetera. And we've never supported that, as Newport Beach, my understanding, kind of did. Our position has always been, no, it's public land. And on top of that, an issue that we have here that Newport didn't have is that portion of the land owned by the county in that deed from 1933 is deed restricted, that it cannot be used for such purposes. And so that's just another hurdle in that would not allow it. And so we've never, as my understanding was Newport Beach did, we've never supported anything that would allow that private use of the public land.
Okay. Anybody else? Okay, my turn. First, point well taken, Commissioner Pointston. What's before us here isn't really the sand issue, but I appreciate Commissioner McPhail raising the issue that homeowners and appellants have raised. However, it's been said several times, and I want to get clarification from staff. I heard Planner Miller say specifically that no permit is required to remove sand. Is that what I heard you say?
Chair King, members of the commission, historically, the homeowners have moved the sand behind their homes without a permit. However, with the new LCP modifications that were recently approved by your body, I believe, and I think even by the board, and they're working their way through the Coastal Commission, permits will be required, and we also move sand down at the Harbor Department. So we will be discussing with the homeowners, how they wish to do that, how they wish to proceed.
Okay, you've kind of answered my question. I didn't hear the whole thing as well as Commissioner McPhail did. But moving on, is there any reason to suspect that the area where the decks are could be construed as ESHA because it's on sand that could be a dune habitat?
It is not currently on area that's designated ESHA. The area, this piece of property that runs directly behind the homes, it actually appears that it was originally intended for either a narrow street or some sort of a boardwalk or a bike path, but it is not near the dunes area, which is the area that's designated as ESHA.
Okay, I just, as I read through it, I just kind of scratched my head, particularly because I saw some vegetation on the sand around some of those decks, and I wasn't sure what that vegetation was. Okay, I think you answered. I had a question about why isn't the Coastal Commission weighing in here like they did in the Newport Beach case? And I think what I heard is, well, if the county doesn't address this, they very well might. And my comment is that what you learn in reading the case of the city of Newport Beach and the Coastal Commission proceedings is that the city, in trying to accommodate the homeowners that had encroached on the beach that they own wound up getting drawn into the proceedings. And it's worth noting that at the end, the homeowners and the city were on the hook for about $1.7 million to remediate. So Coastal Commission has some teeth. So we ought to be very careful as a commission how far we want to go in trying to solve what seems like an unfair position taken against homeowners that have had these decks forever. Let's see.
Yeah, if the Coastal Commission took an enforcement action, the action would be against the County of Ventura as the property owner, not against the individual adjacent property owners.
Right. So there's some motivation to abate these violations as expeditiously as possible. Here's a question for County Council. We're looking at a deed restriction that's almost 90 years old. Do courts tend to enforce such antiquated deed restrictions?
Thanks, Chair King. Yes, if it's on title and it's yeah, there's no reason not to, just due to the age. And I will add, there's a specific code provision, sometimes in situations like this, people might argue they've acquired prescriptive rights or, adverse possession or something. And, that might be a situation between two private owners, but there's a specific civil code, I believe it's 1007. You cannot acquire prescriptive rights on government property. So I think that's an important consideration. But yes, the deed restriction is active and would be enforced. And if someone wanted to argue that, well, you've allowed this development for decades, we've acquired rights to the property, I think that would be rejected because there's a civil code provision directly on point that says you can't do that.
Okay, well, you answered my next question to you, which had to do with prescriptive easements. I had a suspicion there was an exception for public land, and you answered it quite well. Let's see, what else did I have? Now, just a comment, because it seems to me that if I was a property owner that bought the house and there was a deck there and whoever told me it was legal or whoever didn't tell me it was illegal, I would feel ill-used, I suspect, especially if I've been using it for years. Just a thought as you go forward. And I was thinking of the situation where folks have to remove brush from around their properties. They have to clear brush in order to mitigate fire hazards in some areas, and that the property owners have an option to do the weed abatement, pay for the weed abatement themselves, or take their own weed whacker out, or wait until the county comes in and does it at the county's or at the homeowner's expense at whatever rate the county bills. And we have a case here where, depending on how you structure the violation correction, that may be an option that if the homeowner feels like, well, they shouldn't have to do it themselves, the county could come along in the end, remove the structures and bill the homeowners attached or next to those structures for whatever the cost, and then let whatever litigation ensues be resolved with the homeowners council and Councilor Edsall and his cadre of legal eagles. So, I mean, it's just something to think about moving forward that has no bearing on what the authority of the commission in these cases is, but just something to think about And the other thing I thought about in reading these is particularly the homeowner, the lady that wrote that handwritten response, which I felt was done very well. But I got to thinking about, is there recourse for homeowners that feel like, they were taken in? And I thought, well, first I thought about title companies, but title companies are only going to tell you about what's your property. They're not going to tell you about the property next door. So that was, but in cases where sellers and their agents seem to represent that the decks were part of the deal, then maybe the remedy, although not cheap, the remedy is to go back to folks that misrepresented or failed in proper transaction disclosures. So just something for the homeowners to think about going forward. And those are all my comments, unless somebody wants to blast me. No? Okay. Any other questions of staff? Staff, any kind of rebuttal to questions that you didn't get a chance to respond to?
Just one clarification on the sand part that came up. Your commission hasn't taken an action on the LCP amendment related to the sea level rise program. We were back with you in July, I believe, when we went over some of the technical documents. So that discussion and topic for Commissioner McVeigh would actually come to you later next year. It's not specific to sand removal per se, but that topic is a component. So you will have an opportunity to weigh in at that time. So thank you.
Okay. Very good. Staff, anything else? Okay. Now let's see if we have any. I know we have at least one public comment. Oh, wait a second. Commissioner Dukas, did I screw up again? Go ahead.
May we have a 5-minute break?
Oh, certainly. If it's okay with the commission, we'll take a 5-minute recess.
Thank you.
Thank you, Dave, for your comments. Because I knew we hadn't voted on that yet. Yeah, because we just put it down where we have
Is everybody back?
Yes.
Okay. I don't see Renee. Renee, is there any reason why we can't return from recess?
We should be good to go, Commission Chair King.
Okay, in that case, let's reconvene from recess. And at this point, do any of the appellants wish to address the commission? Do you have any, Secretary Verduzco?
Are we asking for speakers now or the ones that were registered?
Well, first, I want to hear from any of the appellants.
I believe.
Chair King, it's possible that they may not have specified themselves as such as they did their registrations in advance. So, Renee, how many speakers do you have in Zoom?
I have 9. I have 9 registered. We're checking to see who is tuned in.
Correct. Okay.
Okay. Well, why don't we do this? As we call or recognize each speaker, if they could at least indicate whether or not they are an appellant or representing an appellant, that would be, I think, helpful for the commission. Is everybody okay with that? All righty, then Secretary Verduzco, why don't you start going through the public comments?
Okay, so we have Andrea Wishnow.
You have the floor, Ms. Wishnow.
Can you hear me?
Yes.
Okay. After listening to everything and what everyone said, I mean, I'm in agreement with all of those homeowners and I have the same reasons as them, so I have really nothing more to say. But
Okay.
thank you.
Thank you. Who's next, Mr. Verduzco?
Next, we have Robert Green.
Okay, Mr. Green, you have the floor.
Mr. Green,
Green,
if you
you're
could please
muted.
unmute. You have the floor.
Can you hear me now?
Yes.
Can you hear me now? Okay. I agree with the last person as well. So, you know, I haven't been able to listen to the entire conversation. I just sort of popped on just a few minutes ago. So my wife, I think, might be on as well. And if she wanted to speak, that might be more appropriate. I think she's been listening. I'm sort of just got on the call.
Mr.
Okay.
Green, we're unable to hear you.
Who was unable?
Her name is Marla.
Okay. I thought I heard somebody say they couldn't hear Mr. Green. No? Okay. Who is next, Mr. Verduzco?
We have Rima Cameron.
Okay.
Hello, Commissioners, Chair King. Before I start my comments to my case, I need to make sure that a statement Mr. Leeper made a few moments ago is not left corrected. He stated to you, the only matter before you now is whether the decks are legal or illegal. That is incorrect. The only matters before the commission today is appeals on specific notice of violations that were issued against homeowners, whether those notices specifically were legally viable and should remain in place. Now I'll speak to the ones specifically to our property. I've provided you documents. You have my purchase and sale agreement. You have photos. We did not purchase this deck. It is not attached to our property. We have in no way encumbered that deck, and it can be removed by the county, as has been pointed out by your own staff report. These decks are on county property. The code enforcement they talk about, yes, if a homeowner purchases something that has a code violation on the property, that was noted as page 8, which as a rebuttal to my argument. By their own admission, this does not, our case does not fall into that category. I understand the commissioners are charged with protecting the beaches. And of course, you can remove any illegal decks as you could have done over all these years. What the commissioners really should not do is issue a resolution that has no legal basis. I have heard no legal authority cited with Mr. Legal's, Ms. Miller's, or Mr. Edsell's assertion that an adjacent structure somehow makes it the homeowner's responsibility. And if you choose to go ahead and issue this, I would like at least some legal authority cited that makes an adjacent structure that homeowner's responsibility. So in conclusion, I understand your concern, and I have no problem with you if you need to take that deck down, but to put the burden on homeowners who have no legal responsibility for that structure would certainly be an abuse of power and something that the commissioners should not entertain. And they should, so therefore our appeal should be found proper, and this notice of violation issued October 10th, 2016 should be rescinded. Thank you.
Thank you. Mr. Verduzco, who's next?
So the next registered speaker was Barry Sanders. We don't have him on Zoom. However, we do have somebody that phoned in. We're not sure who it is.
Okay. Do
Okay,
we have
so-
any other Zoom speakers?
We can move on to the next speaker, Marla Green.
Okay, and we'll pick up the phone in later. Okay, Ms. Green, you have the floor. And you are muted.
I don't have anything to say at this point.
Okay. Thank you. Secretary Verduzco, who's next?
Next, we have Jennifer Paulakos, who is actually not tuned in. The next person we have online is Jeff Catanzaro.
Jeff Contazaro, okay. Mr. Contazaro, you're muted. Mr. Canzaro, you are muted. Hmm. Hmm. Okay.
He may not know how to unmute himself. If you go to the lower left-hand side of your screen, Mr. Canzaro, you can unmute yourself.
Renee, do you have a way to unmute Mr. Canzaro?
No, unfortunately, he would have to unmute himself. It is possible that sometimes members of the public think they have to register in order to watch, and they don't realize that registering is for speaking.
Okay, well, kind of last call, Mr. Canzaro, if you can hear me and you want to unmute by clicking the microphone in the lower left-hand corner of your screen, you will have the floor. If we don't hear from you in the next half minute or so, we'll move on.
If you called in by phone, you can press star and 6.
Okay. All right, let's move on.
Renee, we need to check for the emails. Renee, if you have any of those that weren't part of the speakers, or a speaker who sent an email and wasn't able to speak, you could read their email.
We do. We have quite a few emails. There's one more speaker. Did you want to get to that one first, and then I can read the emails? Or
Yes.
Yeah.
Okay.
Let's take the speaker first.
So the next speaker is Nancy Fairchild.
Okay, Ms. Fairchild, you have the floor.
I have nothing to add at this point. That's fine.
Okay. All right, let's start going through then the emails. And We'll let you just roll right through them, Mr. Verduzco.
Okay, the first email received was from Bob Green, who I believe already got a chance to speak. It's brief, so I'll read it. To the Planning Commission, all asked is that the Planning Commission treat the issue for all houses on Hollywood Beach and not single out these 9 homes. What is decided for one should be a decision for all. The Commission should delay the debate on the issue until a decision can be made for all homes in the specified area. Thank you.
Okay.
The next email was actually a letter that was sent in. I'm pulling that up right now.
We do have a limitation of 250 words, so Renee, you'll have to see the length of that. If it appears much longer than that,
It
it's more
is,
than a
yes.
page, then you may need to just look at the first part of the. Actually, forward that to me real quick, and I'll let you continue on with the others, and I will take a look at that one and see how to.
Okay, it is pretty lengthy.
Okay. All right. Thank you, Renee.
Okay, moving on.
Okay, the next email is Barry Sanders, who is registered but didn't get a chance to speak. His email reads, Dear Miss Miller, I am writing to you as advised in the Notice of Coastal Zone Planning Commission public hearing set for November 18th, 2021. With regard to item 6 on the agenda, as explained on the emails that follow, since November 7th, I have been trying to assure that the notice of violation issued against my house at 3817 Ocean Drive, Oxnard, violation number CV21-0486, will be included among the identical cases being heard on appeal at that hearing. I was out of the country when the notice was received at my home, no more than 10 days prior to the November 7th. In seeking to have my appeal considered, I have been advised by various county officials to call various others, including Jennifer Trunk, and none of my telephone calls have been returned. My concern is to be included so that whatever resolution is decided as to my neighbors, including time periods, will equally apply to me. I attached my appeal form, which was provided to the county on November 10th.
Okay.
The next email is from Andrea Wishnow. Again, she had a chance to speak. This one's pretty brief, so I'll read through it. Hello, I would like to address at the Zoom meeting this Thursday morning the fact that it is unfair and prejudicial to single out our house deck as there are hundreds of other houses with decks on the same beach. Our deck was at the house when we bought it 3 years ago.
Okay.
The next one is another letter that was sent in. I'm checking the length. Okay, so it's not too long. It seems to be less than 250 words. From Hope Slepak. I purchased my home in April of 2016. It came with a deck. At the close of escrow, there were no disclosures concerning my deck or its legality. In April of 2017, I received a violation stating that the deck was in code violation. So shocked by this that I went to the county offices to see if it was permitted. Since so many houses have them, to my surprise, it was not. I have walked the beaches from Hollywood to Silver Strand. While it appears to be a case of selective enforcement, allowing the law to be violated by most, while penalizing some of us, all due to an angry neighbor, I was wondering if there would be some consideration to have a revocable permit to allow us to continue enjoying our outdoor spaces. Our decks do not obstruct or impede the path of anyone, and our taxes are quite sizable. Thank you for your consideration.
Okay. Next.
The next email is from Nancy Fairchild, who was registered to speak, but decided not to. Dear Miss Miller, thank you for taking the time to consider our views on the deck issue on Hollywood Beach. It is a tragic waste of your time and the county's money. The decks are harming no one and don't interfere with the public's access or enjoyment of the beach, of the very wide beach. Both Mr. Kessler and the neighbor who complained no longer own property on the beach, both having sold some time ago. We bought our home over 17 years ago with the deck in place. In all that time, we have had no complaints. Mr. Kessler only complained out of pettiness to get back at his neighbors who objected to the constant large parties at his property. We never heard from him directly. We understand that there are regulations that may more appropriately apply to other situations, narrower beaches, or where a deck would interfere with wildlife or other people's abilities to access or enjoy the beach. We are hoping that regulations can be adjusted in situations where they really don't apply. We're asking that the Planning Commission grant us conditional use permit for the deck area until such time the county has some actual use for the property. If we are required to remove the deck, we ask that at least 90 days to accomplish this due to the holidays and current difficulties getting workers in this COVID environment. We appreciate your thoughtful consideration.
Okay, next.
The next public comment is from Todd Sato. Dear Marilyn, thank you for taking the time to speak with me about the appeal hearing tomorrow for my property at 3829 Ocean Drive. I had requested that the county consider issuing revocable permits to allow the affected properties to keep our non-compliant decks at least temporarily. I now understand there is no mechanism to allow revocable permits in this situation, so I wish to withdraw my appeal and I will remove my deck. As I mentioned, the staff report mentions stairs from my side yard down to the deck. These stairs were presented on the original county approved plans for the house built in 2009. The stairs do not extend beyond my property line and have not been altered in any way since they were constructed as part of the original permit for the home. I am assuming the stairs may remain in place. Also, I believe recent correspondence may have been sent to my old mailing address in Los Angeles. The address was changed in 2020. Please make sure any future correspondence is sent to my current mailing address, which is on file with the county assessor's office. And then I won't read the actual address. The next public comment is from Rima Cameron. I provided documents to the commissioners providing there is no legal basis for the resolution staff has drafted, Exhibit 9 against us. Purchase documents and photos show the deck was there prior to our purchase and we did not purchase the deck. The staff report on page 8, item 8, the basis of our appeal staff states property owners assume responsibility for any issues on the property they are purchasing. Therefore, this assertion has no merit. While the statement is legally correct regarding code violations, what staff conveniently fails to disclose is that portion of their report is that the deck for which we are being cited is not on the property we purchased. In fact, on page 3, staff states that decks are on public beach, and in the table noting details of each deck, under item 6, our deck, it clearly states that our deck is detached from the adjacent block wall. In addition, the proposed resolution to our appeal, Exhibit 9, clearly states that the deck is beyond our property line. I understand the commissioners are charged with protecting the beaches, and of course, they can remove any illegal decks. What commissioners cannot do is issue a resolution which has no legal basis. To do so would clearly be an abuse of power designed to shift the burden of removing the decks from the county who is responsible for maintaining Hollywood Beach to homeowners who have no such legal responsibility. And that's the last public comment. I'm sorry. I got a last minute one this morning from Harry Chandler. And his letter reads, 14 years ago, I built a deck on Hollywood Beach. During construction, I received a call from the Channel Islands Harbor Master who said that he had authority over the beach in front of my house. He said that the deck encroached on public beach, but he would not object to it. If the county at a later date asked him to, the worst thing that would happen to mine and the other non-permitted decks would be a lien would be placed on the property, such that the property could not be sold until the deck was removed. After this call, I relied on the official's direction and finished the deck. Other neighbors on the beach built their decks, also relying on the same conversation. And that's the end of the public comments.
Yeah. Chair King, commissioners, the one additional letter that Renee forwarded to me, I've looked at it. This is actually from Rima Cameron, the one that was your third speaker earlier today. And then Renee had an additional letter that he wrote, read into the record. This email seems to be slightly different. It's 2 pages. It's also attaching a grant deed, but this came in on the 15th of November. So I think it may be in your packet, your distribution already, but the portion of the letter, which I can't read in its entirety because it's longer than 250 words, but it highlights the same same comments that Rima provided earlier, in that the county could remove this deck. There's no legal authority, and it does reference the same citation that Renee read about the portion of the staff report on the specific page, and notes their contention. So I believe you have been informed about their comment. And then there was one comment that was read from one of the emails that I would like Ms. Trunk to respond to.
Good morning, commissioners. Jennifer Trunk here. I actually spoke to Mr. Sanders. I spoke by phone as well as email, and I informed Mr. Sanders that this item had already been legally public noticed and that we couldn't incorporate his appeal after that time. And I explained to him that there'll be another round of property owners that will be going before the commission on the same item. Thank you.
Thank you, Ms. Trunk.
If I could clear up, I know what Jennifer just spoke to. I believe Ms. Wishnow and Mr. Sanders are recent recipients of a new notice of violation just within the last month or two. And so they're not included in this because this action was appealed, as noted, quite some time ago. And the new notices of violation that were issued and have been throughout this last 4 or 5 years to other property owners who have decks onto the public lands, each have their own opportunity to file an appeal as noted in the notice of violations, how to go about that, timeframes to do that, et cetera. And so these new notice of violations would not be included in this because they have their own opportunity to appeal.
Okay. I have one question, I'm sorry, for Marilyn. Mr. Sadow, if I understand his email, said he was withdrawing his appeal and would remove the deck. Is that the case when we began this hearing that you cited as having withdrawn the appeal, or is this a different withdrawal?
This is the same property.
Okay, thank you. I just wasn't clear at the time. Okay. Staff have any comments on the testimony that we have received?
I have no further comment.
I do, just briefly.
Okay, Mr. Leeper.
Yes, thank you. As we've listened to the comments and the emails, numerous new grounds for appeal have come up in that whether the violation notice itself is legal and binding. The appeals that were received by most of the parties, with the noted exception of the Cameron property, was that it is their deck. They enjoy it. It's not hurting anybody. We do use it. It blocks the sand. So there is an admission on at least a majority of them that they recognize the deck as theirs and their responsibility. In Ms. Cameron's case, I believe her appeal stated that it's not on her property, wasn't her deck. And so I do stand corrected, Ms. Cameron. Thank you for bringing that forward, that in her instance, the appeal was that it's not her responsibility. And so when I said the only issue before the commission was the legality or illegality of the decks, in that instance, it would be whether she in fact is responsible to remove it or not. And to that end, as far as any legal standing in the notice of violation, as I noted earlier, we had numerous conversations with county council and administrative staff to determine the legality and foundational support of the action that we're taking. And I can let Mr. Barnes speak to that if he so desires. Thank you.
Mr. Barnes. Oh, Mr. Barnes, you've joined us.
Hi, good morning, Chair King, members of the commission. I have joined you, and yeah, interesting item today. The county's position is that, and this is supported by the Coastal Zoning Ordinance, section 8183-5.6, subpart B. And so the definition of violator is that, so basically it says, violator means the owner of the property on which the violation exists, and if applicable, and here's the key part, a permittee responsible in whole or in part for the violation. And so the county's position is that even if the property owner who now owns the property didn't build the deck, they basically stepped into the shoes of the permittee who previously owned the residential property and that prior property owner's successors in interest. And so the evidence in county council's opinion clearly shows that these decks are all intended as accessory uses to the residences. And so the current property owners are responsible for the violation, even if they didn't actually build the deck. And so I guess, this, and an analogy or comparison I would use, and it's more extreme, but it's exactly the same situation as I believe the evidence bears out here, would be, let's say one of these properties had a fence that went 10 feet past their property line and enclosed the public beach, physically enclosed the public beach, made that land part of their private property. Would these same property owners argue, well, we're not responsible because that fence and a deck on the land that's enclosed by the fence is not on our property? I think the question or the answer would clearly be no. You're basically assuming control, and you're building, your successors have built a structure on the public beach for the purpose of basically privatizing that public property. Well, here, like I said, there's no fences that are enclosing these deck areas, but the intent is still clear, which is to privatize the public beach and to facilitate their use as an accessory use to private residential properties. So that's the county's position there. The Coastal Commission clearly shared the county's position. I'm confident of its legality. And I mean, if you looked at it the other way, and I agree that all the decks really should be treated the same way. If one property owner says, oh, it's not on my property, I didn't build it, you can't do anything about it, then that would seem to apply to all the property owners, even the ones who are admitting that they did build the decks or they are enjoying the decks. They could basically have it both ways. It's not on our property, so you can't touch us, even though, yeah, we love the deck and we want to keep using it, so go away. So that would be, that would, in my mind, create a kind of disconnect there if your commission was inclined to feel that some of the property owners were not in fact responsible, even though, so I mean, and I guess I'm kind of maybe a little bit all over the place, but I think that the main issue in my mind is whether these decks are intended to basically be an accessory structure to the adjacent private property. And if they are, then in my mind, legally, there's a clear legal basis to find the owner of the residential property responsible for the violation.
Okay. Thank you, Councilor Barnes. I have one question I need clarified before we move on, and perhaps Planner Miller can help me. Ms. Cameron's remarks can you tell me which of the properties or NOVs her remarks relate to?
Her property is the 3953 Ocean Drive, which in your list of exhibits is number 6.
Oh,
No, I'm sorry, not 6. 3953 is number 9. It's exhibit 9 to the staff report, 3953 Ocean Drive, PL 170043.
okay. I have that as number 6 on the agenda, and I have my resolutions ordered that way.
Number 6 on the agenda.
Yeah, if you look at the agenda, there's a little chart, and it lists
Yes.
each of the 9 properties, although the second one has been withdrawn.
Yes, that's correct. So in the staff report under item 2, where it lists all the property owners, their locations and parcel numbers, there's this number 6. On the exhibits, it's number 9 because there's several exhibits before the resolutions.
Okay, well, there's a reason I bring this up. Let me see if we can close the public hearing, and then I'll explain where I'm headed with this. Anybody else? Commissioner Dukas?
Well, before you close the public hearing, could I reserve some time for an additional question?
Sure, although, okay. And Commissioner McPhail?
Yeah, just a point of clarification for the people who are listening, regardless of what the gentleman from the harbor said, that really has no legal bounds or whatever. Is that correct?
That's correct, Commissioner McPhail. Thank you for asking. I guess I would, I mean, it's called hearsay because we haven't heard from the harbor. I'm sorry, I can't even remember who the public official supposedly was, but we haven't heard that person say anything directly. So it's kind of second or third or maybe fourth hand information. But even if an official did say that, it would have no legal basis because they wouldn't have authority to speak on behalf of the county, and it just contradicts the law, which is private property owners have no legal right to build structures on the beach, period.
Thank you, Jeff. I just wanted to make sure that was clarified.
Okay, let's go back to Commissioner Dukas. We have reserved time for you.
Thank you. I just want to follow up with Mr. Barnes. If it was evident that the property 3953 Ocean Drive, where she disavows responsibility, if there was a multi-listings packet or photographs available showing the deck as part of what was for sale, does that bolster the position that it is the successor homeowner that has responsibility for that deck?
Good question, Commissioner Dukas. It would. I would say legally that evidence wouldn't be necessary to establish that responsibility, just again based on the proximity of the deck to the private property, but that would definitely undermine an argument of to the contrary.
Okay, just I don't know if it's necessary to disclose that it is on the MLS listings. If you look up that property, if you just, I have another computer here and I'm going back and forth to see which property we're going for. And, the internet is forever and it has pictures of the deck as part of what is for sale. So I make that disclosure.
Yeah, and actually, you know what, thank you so much. You know, what would be helpful is if you could email a link of that to, I would say to Renee or Dave Ward. I mean, ideally, we would put that into the record, and because it's evidence that, that, like you said, that is relevant, so it should be reflected in the record.
Okay, and I apologize for not, doing that sooner. I just, when people are talking back and forth, I'm like, wait a minute, which one is that?
Sure.
So that's how that came up. I'll do that right now.
Okay, thank you.
And the chair notes that Commissioner Dukas did make an affirmative disclosure on this item. All right. Anybody else before I close the public hearing? Yes, Commissioner Boydston.
I just wanted to clarify because Mr. Barnes, on the same property, made the sort of example that the homeowners is, the improvement is not on their property, and so they are balking at responsibility and want to keep the deck based on that and use it. I think from what I heard the Cameron say is that it was an improvement that is not on their property. They're more than willing for the county to take it out. They're not using it, whether they're using it or not. They're not against the county taking it off, but it shouldn't be their responsibility financially to do that. I don't think they're indicating that they want to keep it. So I would only clarify that.
Yeah, no, thank you. And that's fine. And that's your commission's call. I would just say that there is a legal basis to find them responsible, even, based on their statement that they don't want the deck. They're not responsible. They just don't want to have to pay to take it out. My point is legally, there is a legal basis to find them responsible for removing it, basically for maintaining a public nuisance, because there is evidence that it's accessory to their residential use, and they stepped into the shoes of the property owner who presumably did build it at some point.
Yeah, I think that added information, sort of pushes it in that direction. So thank you.
Okay. Anybody else before I close the public hearing?
Commissioners, we have Rima Cameron with her hand raised.
Say again?
Rima Cameron has her hand raised to speak.
Okay, well, I obviously can't see Rima Cameron.
She's the owner. Yeah. She's the owner of the property that we're discussing, the 3953.
Okay.
So Chair King, Commissioner, so Rima Cameron is the one who spoke as an appellant, the number 3 speaker today. She's also the individual that Renee read the letter that he received just as of yesterday, and then I paraphrased from what I could from the other letter from November 15th. So you've had 3 iterations of communications from this appellant. It's up to your commission if you want to reopen the public comment, but I would say that you've already heard from the appellant in multiple ways at this point.
Okay, and I'm going to watch my commissioners to see their reaction. My inclination is to say that this property owner and commenter has had, 3 cracks at it, and I'm not personally inclined to reopen that part of the hearing. We've certainly given a good deal of time and consideration. Unless any other commissioner objects, go ahead, Mr. Boydston.
I guess the question of rebuttal comes up as they're filing this appeal. Is there rebuttal on the part of the homeowners? And I guess, have we heard it already from this person?
I'm kind of looking at you, Nora, because I rely on you. You're neither shaking your head or, okay, Commissioner McPhail, where are you on this?
it's obviously an important issue with the homeowners. I see no reason not to reopen it and let her rebut.
Okay, in that case, I'll go ahead and recognize Mrs. Cameron, but advise you that you are restricted to 5 minutes.
Yes, Commissioners, I do need to rebut the statement that Mr. Barnes made, which Commissioner Boyston also pointed out. We're not standing in the way of the county removing this deck. And just because people say something adjacent makes it subject to the property that no one has cited. I've read through every one of these documents. I don't have any legal authority cited that is true. You can't just say something adjacent makes it our legal responsibility. And I would ask, before you rule on this, please get that legal citing, get a statute, find out. Just because staff says it makes it legally responsible does not make it legally true. And I honestly look through the citing. There is the only thing cited are code violations. If they're on the property is the responsibility of the homeowner. It goes with the property. But nowhere is there any wording that says adjacent proximity makes it that homeowner's responsibility. And if there is, it hasn't been cited, and that therefore this notice of violation should be dismissed. Thank you.
Okay. With that, I am going to close the public hearing. You can find comments and remarks to the commissioners, but I want to say going in that we have to take action on each of the 8 remaining resolutions individually. Certainly commissioners can talk globally, but when we go to take action, we have to go one resolution at a time. And right now I have them ordered in the same order as the property addresses and as they appeared on the agenda. Unless anybody has an objection, I think that's the way we'll take them. Let's start with, are there any commissioners that want to discuss things globally before we proceed? Yes, Commissioner Dukas.
I do think that we did have advice from County Council regarding violator and what that meant. And I also want to say really globally is that in City of Thousand Oaks, many homeowners are adjacent to public open space. Their backyards, there may or may not be a fence, but there is a property line between people's private property and what is publicly owned. Some homeowners in Thousand Oaks took it upon themselves to do some enhancements on that open space that they thought was harmless. Pathways, just ways to use the open space that benefited them. And what ended up happening is that all of those improvements needed to be destroyed, removed, because the land did not belong to them, full stop. And I thought it was very interesting that originally in 1932, what was contemplated was that this strip of property would be a boardwalk, very similar to the Venice boardwalk, where I lived in Venice for years before I moved to Thousand Oaks, Ventura County, where there are bicyclists and pedestrians and sideshows right immediately on the other side of private property. And that was what was contemplated in 1932, according to Marilyn Miller, I believe, if I heard her right. So to me, the issue is very clear that if you bought the property with a use that, even though it wasn't on your property, but you have a use, you are using the property as if it were your own, that is sufficient to make it your responsibility. And certainly, if somebody says, well, it wasn't disclosed, it didn't show up in, all the real estate documents and stuff, the pictures, paint a different picture. That's kind of circular. The photographs paint a different picture. Let me put it that way. That these are definitely ancillary uses. It would be extremely unlikely that any member of the public would feel free to use these private decks for their private party. And I think, honestly, you'd probably get daggerized from the homeowner if you decided to picnic there or utilize some of the furniture or the barbecues or whatnot. It's absurd. So that is my global statement on the appeal. Thank you.
Okay, Commissioner McPhail.
Yeah, I agree totally with Nora on her comments. I just want to clarify, the only reason I brought sand up was because the appellants brought the sand up, and I know it's a mute issue, but I appreciate Commissioner Boyston's comment to stay on course, and I agree with that.
Okay. Any other global comments, Commissioner Boyston?
I totally agree with Nora on this issue. And as we sort of move forward, I think code enforcement talked about the next phase is, how do we negotiate getting rid of these things? What is the process? And I would just say that I would be empathetic towards people that had no idea that this was sitting out off their property when they sort of looked out and saw a whole stretch of these decks. People don't know exactly where their property lines are. So I would be empathetic and looking for ways to help a homeowner along in the process. Not everybody understands construction, let alone demolition and how you do that. And if there are ways to make it easier, as a process for the homeowner and the county to remove these decks in a empathetic and peaceful manner, I would just encourage that to happen as opposed to being combative with the bulldozers, somebody chaining themselves to a bulldozer or something like that.
Okay, thank you. Other commissioners' comments? Let me just, in a global way, weigh in by saying there are really a couple of pieces that come before us. One is the piece of, is a violation valid? Or can the appellant make the case that the violation doesn't exist? And the other piece is, how do you remedy it? And I think that's not before us specifically today. I think that code enforcement still has some latitude, and we've kind of discussed some of the options. And I think Commissioner Boyston is kind of underscoring that fact. And so while none of the individual resolutions finding whether the violation stands or whether it's overturned on appeal, I think there's nothing in there that talks about how eventually it will be remedied. I think we have a good track record with code enforcement of always trying to work with property owners, not to get their money, not to get their hackles up, but to find a way to bring situations into compliance. And I have every faith that that's exactly what's going to happen here. I think when you read the Newport Beach proceedings of the Coastal Commission, they are emphatic in their praise of the fact that property owners the city, the coastal commission work collaboratively to resolve the problem. And so I fully expect that to happen here. Any other global comments? Go ahead, Commissioner McPhail.
This is a question for Mr. Barnes. I know there's 8 separate resolutions, but is there any way we can put them all in one motion?
No, there is. If you're inclined to decide the same way, I think it would be good for all of you to state on the record that you have, just out of an abundance of caution, that you have all reviewed individually each resolution. I think that would be helpful, because that's why we suggested having it separately, so a property owner didn't say, oh, well, my situation is different. It was unfair for you to lump me with all the other ones. So I think that would be good for all of you to state on the record you have individually reviewed them, and that you would like to decide them at once, if that's your will, of course.
Okay, well, go ahead, Commissioner Dukas.
Let me see if I can just craft that in way of a motion. Having reviewed all of the materials, heard the testimony and the staff presentation and the follow-up questions with county council, et cetera, I'm ready to move the recommended actions regarding the following. The addresses and associated parcel numbers, code compliant cases, and planning case numbers that are in our packet on page 3. It is a table, and also containing the appellant's names. Would it be okay? I would like to refer to them by their planning case numbers. There are 1, 2, 3, 4, 5, 6, 7, 8, 9. There are 9 listed, but one has been withdrawn. I believe that is the appellant Sato at 3829 Ocean Drive. And that is PL 17-0048. That has been withdrawn.
That's correct.
Correct.
The rest of those planning case numbers that is in that table in our packet, I would move staff's recommended actions.
Okay. Attorney Barnes, Director Ward, is that acceptable to you guys?
Well, can we at least bring up onto the screen, Marilyn, each of those PLN numbers, if that shows in one of your very first slides? I cannot recall. I know it's in the staff report on the very first or second page, but I just want to, be very clear in the record. What was it? So all of those case numbers there listed, except for, can you identify which, or is it, I can't really see, is it struck through on there? I'm having trouble seeing it.
Yes.
Sorry. Okay.
So Mr. Sadow's appeal was 170048, listed at the end, and it has been struck. I struck it out on the PowerPoint.
Okay.
So those are the case numbers.
So if Commissioner Dukas could confirm that that's part of the motion that you've just made, that would be helpful.
Going through and double checking the numbers with the slide with the ones that is in our packet. And that comports with the ones in our packet, those case numbers and code compliance and planning case numbers and all of the appellants, with the exception of the Sato property at 3829 Ocean Drive.
Thank you.
Okay. So that is the motion. Is there a second? I have a motion by Commissioner Dukas, a second by Commissioner McPhail. Any further discussion?
Oh.
Then will the secretary please call the roll?
Commissioner Dukas,
Aye.
Commissioner McPhail,
Aye.
Commissioner Garcia,
Aye.
Commissioner Boydson,
Aye.
Chair King,
Aye. Okay, so where am I? I lost my agenda page somehow. Oh, here we go. Okay, so motion to deny 8 appeals is affirmed. Moving along to agenda item number 8. That's Director Ward.
Thank you, Chair King and Commissioners. Looking ahead for the board activities and what has transpired, there's only been one item that related to a case you recently heard, which was for the recent zone change for the future LCA contract that was just at your last hearing. So that was heard last week and was approved by the board. We do have a couple of board items hearings that will happen before we next meet as a commission. And that includes on December 7th, the board will hear annual report back on our Land Conservation Act, the LCA contracts, as well as any of the ones that are being designated for this calendar year. And then on December 14th, the board will hear one of the general plan implementation items. It's a program that relates to the study of additional setbacks for oil and gas facilities. So this was one of the programs that was directed for early consideration before 2022. So it's a study that we bring to the board, and then the board will give us guidance on how they want to proceed. So that will be on December 14th. So your next Planning Commission hearing, we have nothing on December 2nd, but on December 16th, we have several items that you will review. One relates to the Agriman Limonera Green Waste Facility project. And then we also will be bringing you a legislative item related to farm worker housing regulations in our non-coastal zoning ordinance. This is one of our final items from the last housing element from the 2013 to 2021 cycle period in implementing updates to those regulations to hopefully produce more farm worker housing units here in the county. So you'll be reviewing that and providing a recommendation as we move forward to the board. So both of those items on December 16th. So I think it will be a full agenda for you that day, but nothing on December 2nd. So we wish you well for next week with the holiday and happy Thanksgiving. And then we would return on the 16th of December.
Okay. Anything from the commissioners?
Everybody have a great holiday.
Thank you.
Yes, you too.
And I'll echo that. I have nothing further. So without objection, this meeting will stand adjourned.
Take care, all.
Thank you, everybody.
Thank you.
Bye.
Bye.
Recording stopped.